actually gone through this specific PowerPoint presentation, right? So the way that and this goes to how the disclosures were initially given to me, and then how they were subsequently.
But why don't you switch places here?
Thank you, Your Honor. So it gets into certain issues. So Officer Chauvin, a 19-year veteran with the Minneapolis Police Department, has completed 844 some odd hours of training. As the court is aware from our continuing education, I go on the CLE and I report I attended this all-day long seminar, but within that all-day long seminar, there's 5 to 6, 7 different presentations. I think that that's ultimately what we see here is we look at Mr. Chauvin's what are called workforce director training records, and it says he attended the 2020 use of force phase 1 defensive tactics presentation. Now, what does that consist of has been virtually impossible to reconstruct. And it goes to primarily how it was originally disclosed to the defense, how it was disclosed from the police department to the BCA, from the BCA to the defense, and then that formed the basis of my earlier motion and earlier proceedings to get a copy of that BCA drive. So when I originally received these training materials, for example, these training materials are 20 to 30,000 pages in PDF format. And you can look at some PDF of a PowerPoint presentation, and it says use of force academy, whatever the topic is. No frame of reference as to when this was given, who, there's no title, there's no dates, there's no information, who taught this course, who attended this course. And some of that information contains very important statements on the part of the Minneapolis Police Department. When I receive the BCA drive much later, and I look at them in their native formats, the reason I wasn't seeing the titles of these presentations or the dates of these presentations is because that's how they were saved on the drive. So it would say 2018 Phase 1 Defensive Tactics, right? So you know that this is now the training material from 2018 from the Defensive Tactics course, or it will say 2018 Crisis Intervention Training, whatever, 2018 Human Factors of Force Training. So the dates and titles of these courses were given on that drive. Now again, you can look and you can see in his workforce director training or his workforce director program that he got credits for this 8-hour day. But again, which presentations were given on that particular day, you can't, there's literally no way to put this together. And I don't think that the state would disagree with that.
Well, let's see if they do. Mr. Slisher, can you tie a specific training module to the date that Mr. Chauvin actually attended?
Your Honor, what we can do is first show the workforce director training, which memorializes
what we can do. He didn't answer the question.
The defendant has attended, and the titles of those different trainings.
Okay.
Then what we can do is have the trainer specifically talk about the materials and curriculum that they've developed for those blocks of training. And
for those dates.
On those dates, for that. So for example, if it's going to be the fall in service, there was a PowerPoint presentation that was developed from the curriculum from that fall in service, and they can say that PowerPoint training was in fact presented. And these materials, they get recycled from year to year. There's nothing markedly different, in my view, from one to the other. They cover the same
His tie not being tied right bugs me. Either wrap it all the way around or put the dimple in the middle. Anyway, that's just me.
The content was imparted on, in this particular class, and that the defendant attended that class.
Well, it seems that a necessary foundation, I think you'd agree, would be this is the training provided on this date that the defendant's records show he attended. Even if it's embedded with 8 hours of other training, I think that would make it relevant. If you have training, but you cannot connect it to a training that Mr. Chauvin was at, it's hard to say then that you've laid the foundation for it. But it sounds like you've got the foundation, am I correct?
Yeah, I think it's pretty clear, Your Honor.
Now, as far as the other issues Mr. Nelson's identified, that seems to be more weight. It goes to weight, and you can cross-examine on it and say, this is a 3-slide PowerPoint in the midst of 8 hours of training on other topics. And that's pure, absolutely fine because it goes to the weight, the evidence, as opposed to its admissibility. All right, Mr. Nelson, one last comment?
Yeah, I guess, Your Honor, I'm not objecting to the admissibility of this training. The question becomes, I think, and I don't think that it's as easy as as it's presented. It's because even some of the things that they've said that they intended to introduce, which are that are clearly from the academy, from the police academy, they're not from in-service records, but it contains the information that may have been a part of some other training. That's where we. So, case in point, there's a PowerPoint presentation from the Minneapolis Police Academy about nerve manipulation and basically joint manipulation, nerve endings, and how to gain compliance through pressing or
Pressure
depressing
points, yeah.
someone's
Trigger
nerve. It's clearly a training material from the Police Academy from 2017 or 2018. Officer Chauvin was not in the Police Academy in 2018, but ultimately it's part of their training. Now, where did that come from? When was it presented to him? I don't know.
I agree with him. You can't say they're teaching the academy today, and since he went through the academy, he must have got it, because the academy changes and they update.
If the Minneapolis Police Department comes in and says, we never train our officers to do X, right, and insert X, but there are training materials that contradict that testimony, that undermine that testimony, I'm not questioning the foundation for these records. These records exist. They all came from the Minneapolis Police Department. But whether or not I need to show that Mr. Chauvin had that specific training, I think is one question.
Well, let me stop you there. It seems like there are two levels here, and I think the foundation for any of this training material is, at one level, if it's certain training, defendant has been
Foundation to get it in is different than an objection on whether or not it's relevant or it's proven. So I think the judge is going to say they can bring it in, then if you want to object, I'll hear your objection.
or this is not the version that he was trained on, that does not seem relevant at all. The only way I could see training that he had not attended, which might be relevant, is to impeach, for example, and I don't know if this is true or not. I just note that Lieutenant Zimmerman said in his 40 years, roughly, on the Minneapolis Police Department, he had use of force training every year. He was never trained to do X. And if you have use of force training that impeaches that statement, I think that's appropriate impeachment. But aside from that,
I said objection. Impeachment's kind of almost same thing. It's just questioning the validity.
admissible at all.
And that was kind of the concern that I had and had raised in terms of why I thought it was important that each side identify those training materials that needed to be or were intended to be introduced, because I agree with the court's analysis. It's an impeachment question on one hand. If as you know, Lieutenant Zimmerman says we were never trained to put our knees on the neck, but there's a Minneapolis Police Department policy that says otherwise, and there's ample training materials that would contradict that statement. That's impeachment of testimony, and certainly should be admissible for those purposes. Now,
Yeah, had he not said that, for example, I don't think it would be admissible, because again, this is training that the defendant didn't have. And unless you can show he had that training, it's not admissible from either side.
and I think that goes to sort of some of the problems why I raised you can't have every single officer come
Right.
in and say this was or wasn't a reasonable use of force, because the training he had may be different than the training that Zimmerman had.
Right. And so we've got so far opinions from Sergeant Pluger and from Lieutenant Zimmerman on use of force. We're going to hear from the commander or the then commander of the training unit about it. Beyond that, I think we have an expert witness from the state and then an expert witness from the defense. Is that correct?
Two expert witnesses from the state on use of force, Your Honor.
All right. We are getting to the point of being cumulative. We're not asking every officer because that's cumulative, but also even having two seems like it might be cumulative, but I'll deal with that later. It just seems like we said early on in the motions in limine, you're not going to be able to ask every officer what would you have done differently, and we're not going to go through that. I've given you pretty good leeway that the sergeant who was involved in the case and the lieutenant who was involved in the case, a lieutenant who's been a peace officer for roughly 40 years, gave his opinion. Now you're going to have the training unit and the two experts. That's it. We're done with it, with asking other officers about the use of force.
And
Sergeant
then-
Yang, you can ask about what the training is on crisis intervention if the defendant had that training.
And so this is where, again, I don't know if the state is intending to call any, so Inspector Blackwell, she's the kind of the top dog in the training unit, but then there are the actual use of force instructors, right? It's the people who teach these trainings, and at least two of whom have been repeatedly interviewed by the state. I don't know if they're intending to call the actual trainers as well, which just puts, like, you know, if Commander Blackwell, she's not...
The trainers is who you want to call, because the administrators and the people up top have pressure from the top to toe the line. The instructors will say, no, this is what I taught. I have vicarious liability. I ain't playing this game. But the administrator will play the game.
Training people, but maybe that's not what they intend to do.
Is the state intending on asking Inspector Blackwell for an opinion regarding the use of force in this case?
No, Your Honor. The state is going to be calling Inspector Blackwell to describe the training facility, the curriculum, how it's developed, how it's set up, how it's administered. She will offer the opinion, or I guess it's not an opinion, it's a fact, that MPD does not train its officers to place a knee on a subject's neck and restrain them in that position for as long as happened. She'll do that, but mainly go through the records and describe the curriculum and the facility and the trainers, how it's staffed, and then the individual trainers will impart the knowledge from the various disciplines. We have, you know, Carrie Yang, who we mentioned, on crisis intervention and procedural justice training. We have the use of force trainer, probably Johnny Mersel. I don't know that I need to have both Mersel and Schoonover testify on the defensive tactics side of it. And then the medical training that the officers receive.
See, the government, like they're showing this video of his knee on his neck 10,000 times, that's what they want to do with every officer that agrees with them. And then the officers that don't agree with them, they don't want to ask. And that's what they're talking about. Cumulative testimony is you're just repeating the same testimony, trying to, you know, program the jury.
What did Mr. Chauvin know? What it was his training? What was his experience up to that date? All relevant. When we start getting into the opinions, how many use of force opinions do we have? It's cumulative, I think, possibly already. But I think as you go through each of those, it's got to be talking about training that the defendant received. Not just, here's trainings we had. Because if he didn't take the training, it doesn't go to his intent or knowledge.
Understood, Your Honor. The workforce records specify what, you know,
Right.
in-service training the defendant has attended, and then we have the curriculum, the materials that were presented, you know, during those training blocks.
And crisis intervention training seems to be relevant to this case. Use of force training is relevant to this case. Medical training is relevant to this case. So all those summaries of the training that the defendant received according to his records and what the curriculum is, that's, I think, all admissible. I think when we start getting into opinions about use of force, I think we should visit about that before we start blurting out opinions. We've already had several And I think we need to go
And
tread carefully because of whether their opinion is something that is the appropriate topic even for expert testimony, because some of this stuff is within the jury's knowledge and they should be able to do without an expert. So, but I think let's just kind of go with that for
Your
now.
Honor, if I may just, as to the cumulative discussion, just
Right.
to add to that, foreseeing Mr. Nelson being an able defense attorney, I would anticipate if I were to just simply try to prove my case with experts, he would say, the state hired some experts to say this was unreasonable, but what do the people who actually do the work say?
Well,
right?
and I think we've gotten 2 of those already.
And,
so.
and that's the reason. I'm just, I need to cover the appropriateness of the use of force really from every angle to give the full picture of the reasonable officer. I understand at some point enough is enough.
Well, let me be a little more clear. I think you have the right to somebody who's actually done the defensive tactics, use of force training, whatever, to give their opinion about this case. But not everybody, not every trainer.
See the problem, and I've told you when I was a cop, if a DA called me in and said, I need a use of force expert, and I went in there and I looked at the case and I gave him my opinion, he goes, if he didn't like it, he'd say I used somebody else. The question is, how many use of force experts did you ask or have review this? Why did you pick the person that you picked? And how many did you not want that didn't agree with you? That's what most defense attorneys don't know.
Have a plan that's consistent with the court's rulings.
And I guess the court will let me know if you feel I'm
Yeah, let's just go sidebar if we have to in the
Yes.
midst of all this. Because as we know, everything's fluid, so. All right, we'll get the...
That means the prosecution just got a wiggle room to say, the court will let me know when I go over bounds, which means I can ring a lot of bells in front of the jury. And then if I go overboard, you tell me and I'll stop. So basically, I'm going to push the limit and I'm going to get as much as I can and get as many opinions as I can. And then if the defense objects, the jury will look like he's trying to hide something and I'll look good like I'm trying to put something out. So the the prosecution just got a little good divvy in there to kind of do this. Let me stop this and make another one for the next witness.